Are you driving?
Just give me 1 second. I'm parking right now.
What are we doing?
Your Honor, we are respectfully requesting an adjournment in this matter, up possibly 2 to 4 weeks if the court would allow.
Okay. So maybe I don't understand something. And he was just driving. And he didn't have a license. Defendant is to turn himself into the Washington County Jail by 6 p.m. today. Failure to turn himself in will result in a bench warrant with no bond.
The moment Bloom's case is called, Judge Simpson's voice gives away the mood, tired and firm. This case has been on the docket for over a year, and today's goal is to finally set a trial date. Things start off smoothly enough. Bloom's lawyer asks for a settlement meeting and a jury trial, all standard, until Bloom decides to get cute. He tosses out a joke about not driving on a suspended license. The judge cuts him off immediately, making it clear there's nothing funny about domestic violence charges. Bloom might think he's being witty, but sarcasm won't fly in a courtroom dealing with serious accusations. He's tried this routine before, but it looks like Judge Simpson is done playing along.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Bloom, who is present.
What are we doing today?
Your Honor, I'm going to be asking the court to set this for the final settlement conference. I know there's one in August. I know there's one in June. I do have a circuit court jury trial for next Monday that's like pretty firmed up.
Got it.
But I can make the August one work, and I'll leave that open and we'll get it done.
Okay. Jury final settlement conference will be set August 9th, 2024 at 9 a.m. Jury selection in this matter will be August 12th, 2024 at 8:30. Both of those proceedings are in person.
I'll let you go.
I was going to try to get you. I was going to try to get you out of the room. Bloom. I was trying to get you out of the room before you said anything. You knew what I was doing. That's why your finger went up.
At least
and
I'm not.
Said,
at least I'm not driving with a.
Venting about missing discovery files like hospital records, police reports, and photos. He claims he's been chasing this paperwork since October, insisting he's still being denied key information. The judge, trying to keep things on track, checks in with the prosecution. Some requests were handled, others were never properly submitted. But Bloom keeps interrupting, making it tough for anyone to get a word in. He also rants about not receiving transcripts he asked for months ago, forgetting or ignoring the rule that those must be requested in writing. The judge reminds him, but Bloom just keeps pushing the argument. It's a textbook example of how he turns every step into a tangled mess. Whether it's from lack of follow-through or just stirring the pot, one thing's clear, he's not doing himself any favors, and it's starting to show.
I said, enjoy the day, enjoy your horse, all that. So I let it go. The time before that, I let it go. But Your Honor, today I need to put something on the record. This is very serious.
put something on the record all the time. Go ahead.
Okay, no, not last time. Okay. Your Honor, this case, assault and battery case, has gone over a year. And since October, I've fought tooth and nail for discovery. I still haven't been given the hospital report, any photos, any. There's a lot missing from discovery still. Remember, since October, we've.
No, I remember you mentioning it, but hold on a second, Mr. Bloom. Has the discovery been requested, Mr.?
Yeah.
Hold. This is why. Mr. Bernstein.
Which discovery referencing, Jeff?
Hospital report that Deputy Swearing says there was a hospital report. There was. I'm wondering how this case was even brought about, Your Honor, because.
Okay, Mr. Bloom.
There was never a report.
Mr. Bloom.
Okay, I'll let it go.
Because you keep asking me questions you know I can't necessarily answer.
Okay, let me get on with the real stuff.
Oh, okay.
For transcripts. No, I still haven't received the transcripts.
Of what?
3/6. Remember, I asked for the transcripts from 3/6. I still haven't received transcripts from 3/6. That's 3 months ago. I know it takes a while, especially this being a misdemeanor case.
Hang on. We have to have a written request for the transcripts. And Mr. Bloom, here's what I'm going to suggest. If you need those, again, You have an attorney. Tell your attorney that's what you need.
Okay, well, this is my assistance of counsel, just like Ms. Barroso has assistants and you have assistants.
I don't have assistants. I have individuals that I work for that are professionals.
Just when things couldn't get more off track, Bloom starts quoting courtroom rules and ethics codes. He accuses the judge of misconduct, throwing around terms like ex parte communication and claiming personal bias. Judge Simpson, clearly caught off guard, asks him to clarify. But it quickly becomes clear Bloom is mixing up unrelated cases and misusing legal jargon. He even references hearings that have nothing to do with his own. Eventually, the judge has had enough, ends the session, and signs off with a firm goodbye. The tension breaks, and it's safe to say everyone in that virtual courtroom was ready for it to end. Bloom might think he delivered some kind of legal McDrop, but all he did was create more confusion. This isn't a podcast, it's a courtroom. And after today, his path forward may be even more difficult.
To clarify what Jeff's talking about, I ordered an audio recording of that hearing, and someone in my office kind of like, we did a transcription of it for Jeff, but I think what he wants me to request is an actual transcript, and I just didn't
Well, and so they can do that, pay for it, and I'm sure it will be accomplished. But if we haven't received a written request for that, then that won't happen. So,
Thank you. Well, I ain't gonna go through all this. I just need to put a little bit on record. Per transcripts from 10-4, you stated that you believe everything a Washtenaw County Sheriff's 22. Washtenaw County Sheriff Deputy says is true. And you believe everything a Washtenaw County Sheriff's Deputy says.
hold on a second. What are you reading to me right now?
Something that I want to state on record, Your Honor.
No, but what
can I do that?
you're obviously stating what somebody else said. I'm just trying to figure out where it's coming
You said.
on the 24th of,
No, on 10-4 of 22.
in this case?
No, you stated that you believe everything a Washtenaw County Sheriff's Deputy says, correct?
I don't recall saying that.
And you were upset that my attorney questions the deputy's authority, authenticity, and requested said officer to be under oath. And there is proof that deputy testified with reckless disregard for truth. You were also misled on 9/13, 10/4, and 11/7.
Mr. Bloom, is this in regard to your other matter?
This is regard to everything.
Well, no, it can't be in regard to everything. It's got to be in regard to your other matter, because this didn't start. No, stop. This case didn't start until 10/18. So if you're referring to a record from another case,
Then I'm past that.
then you're past what?
I'm past the.
After Bloom's courtroom chaos fades, attention shifts back to Mr. Harris, the man who famously drove during his own hearing. His new lawyer tries to steer things toward resolving the case, but Judge Simpson isn't ready to overlook the viral blunder just yet. The real issue? Harris has been insisting for months that a mistake kept his license suspended. But here's the twist. He never had a license in the first place. Not in Michigan. Not anywhere in the US. The judge lays it out plainly. You can't suspend something that never existed. What Harris framed as a paperwork error now looks more like a complete misrepresentation. And with that, the court's patience is clearly wearing thin.
Which in part reads, a judge shall not initiate, permit, or consider ex parte communications or consider other communications concerning a pending or impending matter that are made outside the party's presence or their lawyer's presence. Canon 3A4B in part reads, not only is it a gross breach of the appearance of justice when the defendant's principal adversaries are given private access to the ear of the court, it is a dangerous procedure.
What are you, Mr. Bloom? I'm going to stop you, because what are you talking about?
I'm talking about the transcripts from 3-6, Your Honor, where you stated you had notes, you stated you had a phone call from ex parte communicators.
No, that was regarding your dental?
Yes.
Yeah,
that was a motion we filed.
No, but that has nothing to do with the case.
But I mentioned that on
And
other things you did that.
Mr. Bloom, no, Mr. Bloom,
You don't
because
wanna
if you're
hear
going to, you don't want to hear, I don't. Because what
know.
you're saying is incorrect.
Okay.
I had a communication.
All right.
I disclosed that to the parties because it came to the court's attention, not by the court doing it, that there was something regarding the dental work. I don't know what it was about the dental work.
There were other matters you did the same thing, Your Honor. I'm not contacting
Goodbye.
Senior
Goodbye.
Commission.
Goodbye,
I'm
Mr.
contacting
Bloom. Goodbye. Thank you. Have a great day.
Like your horse.
Take care.
Where you're at. We'll contact the Senior Commission, sir.
Have fun.
Mr. Harris once claimed that both the friend of the court and the Secretary of State dropped the ball, saying they failed to lift his license suspension. But Judge Simpson takes a closer look and finds no mistakes. The agencies followed the rules. The problem? Harris never paid the reinstatement fees, never checked on his status, and never followed it through. The court even reviewed the records to confirm it. The judge spells it out. This wasn't a system error, it was a personal one. And that matters, especially when asking the court for leniency. Instead of owning up, Harris built a story that's now falling apart.
Chris, how are you, Your Honor?
We will see.
We're good. We're good.
Mr. Brown, or somebody from the PD's office, because I did not get a substitution. I got an appearance.
Oh,
I
I've
get
got
a
a substitution right here.
Signed off on.
It is.
All right, then I don't need to address. I don't need
Thank
to
you.
address the public defender's motion to withdraw. I'll consider that withdrawn, given the substitution. I do have an appearance, and I will sign off on the substitution.
Thank you.
Thank you. All right, what are we doing today?
So, Your Honor, we were going to, there's several options that my client,
Well, and I want you to know, counsel, that because of certain things, the court has a number of things I have to say.
okay,
Because I think the record, given particularly some of Mr. Harris's comments with reference to this court potentially acting what at least as I'm to understand is on what some may be, or is it, let's put it this way. People are saying, and quite frankly, your client has made the assertion that the Pittsfield Township, as well as this court, was acting on some type of defective or faulty information, which I will tell you, counsel, caused the court, given what the court did, to investigate what my ruling was. And I will tell you that that assertion is absolutely correct with reference to any faulty information that either came through to the Pittsfield Township Department of Public Safety or to this court ultimately at the May 15th hearing. And I think it needs to be stated, I've been asked for comments. I have refrained from comments, as is my normal practice is. This court with the pending case will speak on the record. And so I am going to make sure that the record is very, very clear as to what this court knows and what this court acted on May 15th. And we can start with this. And my basis for doing it is because of what was said about what this whole process was. And that an indication, counsel, and I know, counsel, you've been before me before.
Absolutely.
I know it is not coming from you, but you also know how I am.
I do.
And the thing is that if for whatever reason, the one time in my life I was wrong, I will say it, and did. But when I'm not wrong, and when people are not to blame, then it also needs to be said. So I will try to get through this as quick as I possibly can. But I will tell you, first of all, with any reference to your client having had a license on that day, and some indication or misunderstanding as to whether or not he had a license, let me make it very clear, based upon what the court looked at, he has never had a Michigan license, ever.
Mr. Harris told both the court and the media that he couldn't visit the Secretary of State due to injuries from a car accident. He claimed he was housebound and physically unable to go. Records show he went in person on December 28, 2023, and even got a new Michigan State ID. Judge Simpson presents the exact date, time, and receipt, leaving no room for doubt. What frustrates the court most isn't just the lie. It's how pointless it was. Harris could have avoided all of this with honesty. Instead, his choice to mislead is now costing him more than just credibility.